Mr. Berman.
Good morning, Madam Chief Justice, members of the Court. May it please the Court. My name is Joseph Berman. I am here today representing the respondent in this matter, Jody Grossman. This is an appeal from a decision of the Single Justice for Suffolk County in a bar discipline matter. The Single Justice, Justice Spina, imposing a sanction of indefinite suspension, and it is our contention that that sanction is incorrect, unduly harsh, and fails to give proper credit to the respondent for a factor in mitigation, and specifically the delay in the commencement of the proceedings.
How long was this delay?
Well, Your Honor, it depends on your starting point. The offending acts, if you will, and just by way of background, what we're talking about here are three unauthorized withdrawals from a passbook savings account. One of those was found by the hearing committee to not be improper, so then we're down to two. Those occurred in the time frame the withdrawals occurred in the time frame between 1990 and 1992. The chronology then goes like this. Bar counsel, on a grievance filed by another lawyer, commenced an investigation in March of 1994. The respondent timely replied to bar counsel's inquiry with a detailed written response on May 13th of 1994. Included in that response, she produced various documents that bar counsel had requested. She supplemented that response 2 weeks later on May 30th, 1994. At that point, nothing happened for over 4 years. The next thing that the respondent heard from bar counsel's office after the correspondence in May of 1994 was correspondence she received, or her prior lawyer received, in July of 1998, again over 4 years later. At that point, apparently, the investigation became reopened. Through her then counsel, Ms. Grossman, the respondent, produced additional records. There was some additional correspondence at that point, and then again the case went, for lack of a better phrase, into the deep freeze. So
Can I just ask you this, Mr. Berman?
Yes.
There is a recognition by bar counsel that this investigation took far too long, and bar counsel has not sought to excuse or justify that delay. However, it is the position of bar counsel that, quote, any mitigating effect of bar counsel's delay is offset by the, quote, protracted nature of the respondent's misconduct and the aggravating circumstances presented. It would be helpful to me if you could address what is, it seems to me, a concession by bar counsel that in light of this inexcusable delay, it would be a mitigating factor.
I will, Your Honor, if I can just finish up my response to Justice Ireland's question, because I think I was giving a convoluted answer. I never got to the actual answer. The disciplinary proceedings started in 2002. So if you go from 1990 or 1992 until 2002, you're talking 10 to 12 years. Now, in response to your question, Madam Chief Justice, bar counsel has, I think, forthrightly conceded that there is no excuse for the delay. It is the respondent's position that this case presents a very unique set of circumstances that this Court has never had to address in the previous times that it has addressed delay in bar discipline cases, specifically Kurlinski, matter of Abrams, and matter of Gross. It would be our contention that in light of the unexcused delay here, that mitigation ought to be considered, that the respondent should be given credit, substantial credit in mitigation because of that delay, and that the respondent has already been essentially punished enough.
Could I just ask, again, on the facts, how much money are we talking about? It's less than $1,000?
It's actually an even $1,000, Your Honor. Two separate withdrawals of $500 each. And one of the points that we make on our brief, the hearing committee, when they issued the hearing committee found that there were violations of the disciplinary rules and imposed a sanction of 1 year and 1 day. And the hearing committee, the only body that actually saw the witnesses, heard the testimony, got to see everything firsthand, found that the respondent's conduct, as found by them, was at the low end of the scale, or at the opposite end of the scale. And I think, although they weren't specific, I think they were talking about, one, whether there would be a likelihood of repetition, but also, I think, taking into account the amount of money.
So what do you say the penalty ought to be?
I would suggest, Your Honor, that the penalty ought to be a public reprimand. Now, the respondent has already been suspended pursuant to the single justice's order for almost a year. And you obviously can't unwind that. You can't put the horse back in the barn once that's been done. But there has been...
So in other words, in some respects, the penalty, the discipline recommended by the hearing committee, she has in essence, which is a year and a day, she has in essence already been subjected to.
That's correct, Your Honor. In late December of this year, I think that we'll be at that period, and here we are on November
What about
9th.
the altered passbook? I'm not quite sure I understand how, but there was a passbook sent into Bar Council which did not show the withdrawals, and then the original one did. So something happened, that records were falsified. Bar Council attributes at least part of the delay to the fact that at first there was no reason to assume that there had been an altered passbook submitted.
Well, and with all due respect to Bar Council, I would argue that argument doesn't hold any water for a couple of reasons. First of all, yes, there was an altered passbook that was submitted to Bar Counsel's office. However, Bar Council, and that was in May of 1994, presumably that would serve as the justification or excuse for some of the delay between May of 1994 and July of 1998. However, the reason that I would disagree with Bar Council, respectfully on that, is that when the investigation was reopened, Bar Council was able to very quickly discover that the passbook had been altered because they subpoenaed the records directly from the bank, got the original passbook. Prior counsel for the respondent submitted an undoctored or unaltered passbook. So it's not a question that they had to go digging around into the ends of the earth in order to find
No,
this
but
fact.
it isn't that it would take so long mechanically to do it, but it would be that was there reason to suspect that the passbook had been altered?
Your Honor, if Bar Council had gone off and done a bunch of investigation based on what was submitted in May of 1994, and those all were sort of, dead ends because, the facts didn't substantiate that, we might be able to get somewhere with that argument.
But
However,
the problem is here, if you look at Bar Counsel's letter to her in 1994 and her response, it really was, first of all, sort of all about the money not having been paid over to the subsequent attorney.
right.
And her response was, well, here's the passbook, the money's here, and oh, by the way, this is a really complicated matter with lots of sordid history, and I'll turn it over once I get something from successor counsel indemnifying me in some respects.
Well, that's correct.
And so it all sort of seemed to sort of drip off as not terribly serious, where if in fact the passbook had been presented in an unaltered form, it would have flown off the page.
Well, not necessarily, Your Honor, because the passbook in and of itself wouldn't necessarily have shown that those withdrawals weren't proper, and it's the respondent's contention that those withdrawals, the three that were at issue, and the hearing committee certainly found that one was in fact proper and correct. It wouldn't have necessarily, set off any sirens at that point. But,
setting aside the question of whether the falsification of the records in the passbook justifies delay, let's assume it either doesn't or justifies only a very little bit. It is still a very serious factor in aggravation here, is it not?
the issue with the passbook?
Yes, the falsification.
It was never, although it was actually alleged as part of the facts and the allegations in the underlying complaint, Bar Counsel never pled specifically as a factor in aggravation that the passbook had been altered. And I don't think that they, and in response to our mitigation defense, never said as a defense to mitigation in a pleading, this is why the delay has occurred. I agree, Your Honor, and the hearing committee.
Lack of cooperation with Bar Counsel
and
is
the
viewed
hearing
as a factor in aggravation, and seems to me that to submit to Bar Counsel falsified records that delete the transactions that would obviously be of importance is a rather extreme form of not being cooperative with Bar Counsel.
I would concede that point, Your Honor, and I would also direct your attention to the hearing committee's report. That issue was presented to the hearing committee. They dealt with it. They decided it, and their findings ultimately, as findings of fact, conclusions of law, took that into account in their ultimate recommendation.
And I go back to the delay. Would you agree with me that if this had been handled properly, which I would interpret to be somewhere around 1995, 1996, the investigation started in 1994, so if they had done it within 2 years, based on what they found occurred, indefinite suspension would be compelled, would it not?
Well, I disagree, Your Honor, and we addressed this at some length in our brief when we addressed it with the single justice, that the case law changed. Obviously, when this Court decided the Chauffeur case in 1997, arguably a year after your hypothetical about when this matter should have been brought. Prior to 1997, although the three attorneys' case from the 1980s had set forth the presumptive sanctions,
correct.
There was a great deal of flexibility. And if you look at this Court's decisions from the pre-Chauffeur era, between, say, even the three attorneys' case in 1987 and Chauffeur 10 years later, you'll see a variety of sanctions for this type of conduct, all the way, to a public reprimand. The point that we make on our brief, and that I want to stress with the Court, is that the Court had pre-Chauffeur and exercised a great deal more flexibility and addressed each case on its individual merits, as the hearing committee did here in finding that this conduct was at the low end of the spectrum. Bar counsel's position is, it doesn't matter that it's at the low end of the spectrum. Chauffeur took away any kind of discretion or ability to sort of tailor the remedy.
I guess what I was trying to say, the delay is bad, it's obviously bad, but she got to practice for this in a whole length of time. So doesn't it cut both ways?
Well, I don't think it does, Your Honor, because I think we have to think about these things realistically. You're a lawyer, a sole practitioner, you have a bar discipline investigation hanging over your head. You don't know every time you open the mail, you don't know what's going to be coming from bar counsel's office or from the BBO. That has an incredibly negative impact on one's ability to grow a practice, develop clients.
Did she make motions to accelerate this, to say what's going on? Well, how come it hasn't been resolved? Did she call up Dan Crane or whoever it was in those days?
Your Honor,
what did she do? Did she just sit back and wait?
She did, Your Honor, and she didn't because, remember, until 2002, there was no formal disciplinary process by which she could file a motion. So, and cases are often...
That was an investigation is ongoing, right? From 1994 on. And she received no communication saying we've resolved this, the investigation's closed.
Absolutely, and in that circumstance, we can all individually, disagree as to how one might want to proceed if you're a lawyer in that circumstance, but some people feel as if I'm going to just wait. I don't want to instigate anything. I don't want them to feel as if I'm being impatient and trying to rush them. I would respectfully suggest, Your Honor, that it's entirely reasonable for a lawyer to not try to push bar counsel at that point.
I guess I'm suggesting if there's an inordinate delay here, despite the concession by bar counsel, it's contributory delay.
I guess I would respectfully...
If there is such a thing.
I would respectfully disagree, Your Honor. I think that given the practicalities that the respondent found herself in, the real-life situation of trying to conduct a practice with this investigation hanging over her head, that there was no contributory delay whatsoever. Once bar counsel reopened this investigation in 1998, they were able to very quickly get it on track, but then it again stopped for another 3 years, and then it was 4 years actually before they filed the petition.
Let me ask you this, Mr. Berman. Can I get to this point, which is intriguing to me, but I don't see much at all in the decisions of the hearing committee or the board. Ordinarily, we have said that delay is not a mitigating factor unless there's been some prejudice, and that's usually viewed in the context of prejudice in preparing one's defense or one's response, which of course makes sense. And actually, the hearing committee finds that there was prejudice in this case on that very score. Right?
Correct.
That she was prejudiced because memories have faded, documents have no longer been kept in storage, the whole 9 yards. But the board then says, yes, but there's no sense that any of that, in fact, actually prejudiced. There was no finding that any of that actually prejudiced the proceedings, the counts on which she was found to have violated. But leaving that aside for a moment, in Gross, we sort of took the next step and said, well, there can be other kinds of prejudice, too. Right. This public thing hanging over your head for a decade also can be prejudice. But we put it in terms of public, hanging stuff.
Opprobrium, I think, is the word
opprobrium. I'm not good at pronouncing words like that, so I try to avoid them at all. But here is another kind of prejudice. You make the point in your brief, but I don't see it in the proceeding, and that is the fact that the lawyer, his or herself, is incredibly limited by this thing hanging over their head.
And there was evidence in the record to support that because the respondent so testified. I would argue, Your Honor, that there was actual prejudice in the conduct of the proceedings here. It's in the record. It distinguishes this case. It's what this Court was looking for in Kurlinski and Gross, and it's here based on faded memories, particularly on the issue of whether she was entitled to pay a fee, to be paid a fee out of the estate proceedings. The memories had faded. Ms. Botello, one of the clients, had thrown out her documents a year before she was contacted by bar counsel. She apparently had never been contacted until 2001. She threw out her documents. The client's, her memory, her brother's memory was very fuzzy on that. The respondent testified clearly that she was told she could be paid a fee. So there's the prejudice in the actual proceedings. But you're correct, Your Honor, that there's also record evidence, and I think that the Gross court, this court in Gross, invited this type of inquiry, which is the real practical effect of what this means to a practicing lawyer, particularly a solo practitioner, trying to carry on a practice with something like this hanging over their head. And I think that that is prejudice that ought to be recognized as a mitigating factor.
Mr. Berman, with respect to the board's recommendation, as I read the board's recommendation essentially says we're going to take into account, so that the 4 years is in essence 1 year below indefinite suspension because you can't reapply. And so would I be correct in reading it that way, that the board, notwithstanding the fact that the jurisprudence appeared to change in 1997?
Madam Chief Justice, if I understand your question correctly, yes, the board did impose a sanction of a 4-year suspension, finding that, in essence, the delay warranted a 1-year reduction off of the indefinite. Interestingly, the board also found that, in this case, delay ought to serve as a mitigating factor, even if there were no prejudice.
Yeah. Thank you.
Thank you.
Ms. Glass-Weisberg?
Good morning. May it please the Court. Susan Weisberg for the Bar Council. I will say, as I have said throughout the proceedings, that Bar Council makes no attempt to excuse this inordinate delay. I would, with the deepest respect, however, suggest that in so doing, Bar Council has not conceded that the delay in this case is either extraordinary or otherwise in any way.
Well, I hope Bar Council is conceding that it's extraordinary.
I am.
But you're not you're not conceding that what the single justice found or said, that it wasn't prejudicial, and that's the key factor.
I do suggest that although the delay is unjustified, it's painful for me to stand here today. It is a painful fact that the delay in this case was inordinate.
What do you do with his argument that had this been handled expeditiously before Schopenhauer, whatever it's called, was decided, the result might very well be a lot different?
Well,
and how can lawyers be clairvoyant and figure that, there's a case might come down that says, okay, from now on, this is the way it is?
It's sort of like the wind farm case. It's very hard to go back and say the likelihood of what would have happened.
No, but
I have several responses, and I don't mean to be jocular. This is a very serious issue. Number one, matter of Schopenhauer came out in 1997. At that time, the respondent still had not paid back this money, and the deception and fabrication of this passbook, and I commend you to page 133 of the appendix to see the fabrication, and 154 to see the actual passbook. None of that had been discovered. It's true that Bar Council didn't discover the alteration until 1998. It's unfortunate that we were so easily misled by the false passbook, but the truth is we were misled, and we shouldn't have had to second-guess that passbook. We should have been able to rely on a passbook that was submitted by a lawyer in response to a request for investigation. So the first answer is that when Schopenhauer came out, the respondent's misconduct was ongoing. She was still holding on to the money, and the deception had not been ended. The second is that Schopenhauer itself made clear, and I believe the word was required, that the court could not, in light of the inconsistent prior determinations, the court was required not to look to intervening precedent to determine what the appropriate sanction should be. As Justice Spina noted in his memorandum of judgment, Schopenhauer himself had engaged in his misconduct in the late 1980s, 1986, I believe, and the decision came down in 1997. So the second point is that Schopenhauer itself tells us that a hindsight look at what might have happened with earlier misconduct is something the court is required not to do. The third point is that even during that period, it's hardly true that conduct like the respondents, which involved converting money, lying about it, concealing it, and fabricating a document to mislead an investigator, that kind of conduct would have warranted a public reprimand. There certainly were cases where lesser dispositions were imposed, But there were also other cases where disbarments or indefinite suspensions were
And I
imposed.
suppose when you do what is considered one of the most treacherous things a lawyer can do, namely take a client's money, you ought to be aware, if it hasn't been fully, disposed of yet, that the law might change and require a much harsher penalty.
Well, I would submit,
I mean,
and
it's not criminal law where they can't, revise a statute and punish you retroactively. It's just, sort of the way things would occur with lawyer discipline.
I would suggest that the law didn't change, Your Honor. The three attorneys case came out in 1984. What Schoepfer said is that it was reaffirming the principles of Schoepfer. And I have cited cases in Bar Counsel's brief where lawyers were indefinitely suspended for taking very small amounts of money in circumstances where there was compelling personal or other mitigation. So it's not a novel concept that a lawyer who takes money intentionally, doesn't pay it back for 8 years, evades and lies to the rightful administrator, and then falsifies a document, should expect a significant sanction. And, I would like to touch for a moment on the issue of the amount of money. This Court has never held that the dollar amount of a conversion affects disposition, and I would suggest that would be a poor message to send to the public. And it must have been important enough to the respondent to have held on to it for 8 years and fabricated a passbook to conceal it.
Ms. Weisberg, could I ask you this?
Please.
The single justice, in dealing with, the gross actual prejudice standard, points to the fact that she didn't raise what would typically be the claims of prejudice with respect to the lengthy delay. I haven't read the board's decision. Could you tell me how the board, I take it that the board, first of all, agreed with you that Schoepfer was the stand, that the appropriate discipline was indefinite suspension. How did the board get from that to a 1-year reduction?
The board said that it was troubled by the hearing committee's determination that there was prejudice because the prejudice, so-called, identified by the hearing committee either related to collateral matters entirely or related to factual allegations by Bar Counsel that were resolved in the respondent's favor. That is the third taking of money that was resolved for the benefit of the respondent, as in Kurlinski. The court said, the board said, nevertheless, it was troubled by the extraordinary nature of this delay and the possibility for prejudice. And on that basis, I believe, recommended the 4-year suspension. If I may, to answer Justice Ireland, the delay in this case from investigation to petition was 8 years. The time in which the respondent held on to this money before she turned it over was 8 years. The delay in matter of Gross was a little over 6 years. The difference between Gross and this case in time is not insubstantial, a little over 6 years and 8 years. But there are differences between this case and Gross that militate against walking away from the Gross standard, which is actual prejudice and substantial actual prejudice. Gross's misconduct was over and done with before the complaint came to Bar Counsel. Like this case, there's no evidence in the record of Gross that Gross posed any uniquely complicated issues or required any uniquely complicated investigation. That's something the board touched on. Third, there's no evidence that Gross contributed in any way to the delay in the case. Now, you can say what you will about the significance of submitting the passbook, but the truth is it didn't lead Bar Counsel to discover that the respondent had intentionally misused this money.
And no matter how we slice the case up, the fact remains that that passbook was falsified.
It was.
And as my sister said, that's very serious stuff.
It is, and it's no longer disputed. The findings of the hearing committee as to this misconduct, the passbook fabrication, which the hearing committee expressly found was done for the purpose of concealing the respondent's wrongful takings, the conversions themselves, and the misleading and false representations made and evasions made to avoid paying this money back, all of those findings are now established for purposes of this appeal. I think that one of the things that Judge Spina focused on, to answer the question of weighing any possible mitigating delay against the aggravating circumstances. One of the things that Judge Spina focused on was lack of appreciation or lack of insight in this case. You know, a long time has passed, and it should never have been this long, and we're working very hard in our office to make sure it never happens again. But the fact remains that in her brief in this appeal, this respondent was still characterizing her misconduct as minor in nature. This tells us that she still does not fully appreciate the corrosive effect, not only of taking money, but of lying about it after the fact and fabricating a record to conceal it. Records are our currency. When I submit a brief to you, I am vouching that what I've written in it is true to the best of my ability, even if I didn't have to sign a certification. When we ask lawyers, show us your records, where did the money go? And those lawyers send us documents, we shouldn't have to look to say, gee, is this real? Is it fake? And this was not a crude forgery either. This was a clever one. It took some time, and it was clearly done, if you read the hearing committee's report, on the eve of the submission of the document. This was not a momentary lapse. This was not a panic response. This was a very specific effort to mislead us. Unfortunately, it did.
Ms. Weisberg, the single justice appropriately pointed to the fact that, I think, looking for actual malice, because that was actual prejudice.
Yes.
But it seemed to me that he didn't address the second part. I mean, in other words, he looked, as I said earlier, to the classic one, lost documents, faded memories, and so on and so forth. How would you respond to Mr. Berman's argument that there's a different kind of actual prejudice, namely, you have this hanging over your head. It's a chilling effect, and he says, that's my term, he says that she testified to that, so there is record evidence of that.
This is what I believe I characterize in my brief as the so-called private impact argument.
Right.
Something that has not yet been recognized by this court, and I'm not suggesting that it should ever be recognized, because I believe one gets to a point in a disciplinary proceeding where a lawyer is emotionally or otherwise distressed and his or her life is on hold, and there are many reasons that could happen. The misconduct itself, a guilty conscience, the impact of having to go through the proceeding, and the disposition. I would suggest that inquiring into the private impact of a bar discipline proceeding would be a marked departure on any count, but particularly unjustified.
That would be present in every case, too.
Present in every case, yeah.
Well, I think a lawyer who wasn't upset by a bar discipline proceeding would have
But
other
she
issues.
could have picked up the telephone and called your office and said, what's going on with the case, right?
Yes, and to cut to the chase, having this cloud hanging over this respondent's head was certainly, I would suggest, less onerous than having a disciplinary finding and a loss of practice.
I'm looking at it from the other point of view, that we know, and Bar Counsel has said, I mean, essentially, and I'm not putting words into your mouth, but there was prosecutorial misconduct. And as a general matter, we don't just ignore that when it comes to a sanction. And what I have not got from you, other than an apology, is what would be the appropriate sanction in this case. Essentially what you're saying is, I've apologized, it embarrasses me, I'm sorry, we're doing our best, but don't do anything about it.
I'm suggesting that the teaching of Gross and Kurlinski is, don't do anything about it, to be blunt, in the absence of demonstrated prejudice. As far as the issue...
And I'm not so sure that, and as those cases haven't led, I mean, we shouldn't be having another 10-year case.
Aren't you really saying, don't do anything about it? Aren't you really, to put it in proper legal terms, saying, yes, there was misconduct in the sense of the delay, but it has no legal significance because prejudice can't be shown, just like evidence that's incorrectly admitted, if not prejudicial, doesn't get a defendant a new trial.
I don't mean to be coy, but I'm hesitant to use the word misconduct. Things don't happen in a case for a lot of reasons. The record doesn't reflect any excuse in this case. I hate to necessarily concede that there is misconduct by
We
the Bar
won't take it
Counsel's
as, we won't
office.
take it as a concession.
I am concerned, however, because we can't ignore the fact that there is a considerable view among at least the organized bar that, notwithstanding their attempts to draw to Bar Counsel's attention the fact that, these cases go on and on and on, and if this court doesn't deal with that in some kind of matter, the Bar Counsel will go on and on and on.
Fair, more than fair to point out. My answer is, first off, this case was filed in 2002, and as Your Honor is aware from reports from the Bar Counsel, things have changed since then, and we are working to make them continue to change. My point is, in this case, there is good reason not to go down the path of taking the effect of delay as having significance sufficient to overcome both the misconduct in this case and the aggravating circumstances. Mr. Berman has said there is testimony in the record about personal suffering. That's true. There is probably personal suffering in every bar discipline case. There was uncorroborated testimony of lost job opportunities, but without any linking to the fact of delay. And in fact, I would suggest that we have to remember that between 1994 and 2002, this respondent was able to practice with the fact of the disciplinary investigation confidential. During that period, she testified, and her witnesses testified, that she worked zealously on major litigation, she expanded her practice, and in short, the record does not prove even the private impact that she claims. So
Certainly in 1998, as soon as Bar Counsel contacted her former employer, who was referring cases to her on a case-by-case basis, the employer said, "That's it, no more for you."
the employer
That's
said...
right in the record.
That's true.
No more.
But had Bar Counsel acted more diligently in 1994, the employer would have said, "That's it," in 1994. So, in fact, the respondent enjoyed an extra 4 years of that income.
I would also say that the private impact argument certainly has, your rejection of that, or you're encouraging us to reject it, has a lot of merit in the average case, but shouldn't, in a case where there has been such extraordinary delay, isn't that just different? Isn't that something that just compels us, as it did the board, as it did the hearing committee, to offset some punishment here, because there's been punishment of a sort?
As I've said, I believe the delay is not legally different from the delay in Gross. There are no findings of private impact in this case. The respondent has never asked to supplement the record to offer evidence that would warrant findings. There are bare assertions in the record, but there are no findings. There has been harm here, but we should also not forget that there has been harm to the public due to Bar Counsel's delay. It is not the right message to send to the public or the bar. The question, however, is whether that harm to the public when Bar Counsel delays should be compounded by inuring to the benefit of this respondent, and I suggest that would not send the appropriate message.
Thank you, Ms. Weisman.
Thank you.